The Supreme Court heard arguments Tuesday on what the Constitution considers taxable income. The case looks at a provision in the 2017 Trump-era tax law. It allowed a one-time tax on shares in a foreign company, whether those shares had been sold or not. If that interpretation wins the day, companies that paid taxes could request refunds. It would amount to a tax cut. But even low-tax fans like former House Speaker Paul Ryan say redefining income would cause chaos.
I think it's a misguided challenge. I'm not for a wealth tax, but I think if you use this as the argument to spike a wealth tax, you're going to basically get rid of, I don't know, a third of the tax code.
Let's bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson. Jessica, let's start at the beginning here. What is the debate about in terms of taxable income? What are the two sides saying here?
So the 16th Amendment provides that Congress has the power to tax income, and the threshold question is whether or not that income needs to be realized or not, essentially whether or not it has to be distributed before it's taxed. And the challengers here are saying, yes, that income has to be distributed. It has to be in my hands. And the government is saying, no, there's no such requirement in the 16th Amendment, that the drafters of the 16th Amendment knew the difference between realized and unrealized, and they decided not to designate. The government in the alternative is saying, even if we lose on this realized, unrealized distinction, this was, with respect to the plaintiffs, realized money, and so we still win.
So now there is this narrow question of this specific case, but former Speaker Paul Ryan and others are looking at the broader implications here. So help us understand why there would be such broader implications and how broad they might be.
I think huge implications, and that's why you see people from across the ideological spectrum saying there's up to, for instance, Paul Ryan mentioned, up to a third of the tax code that could be called into question, in part because of what we just discussed, that distinction between realized and unrealized. If the Supreme Court says, if you, Congress, want to tax income, it has to be realized, that would change, for instance, our understanding of when we can tax real estate partnerships, business partnerships, S-corps, foreign corporations that have U.S. citizens as partial shareholders, as partial owners. So we are certainly not just talking about this one provision of the 2017 law at issue. We're talking about many other parts of the tax code.
And is there some original clue? You mentioned that the Constitution could have made a distinction and didn't, and that gives some clue. Are there other places in the founding documents or debates or conversations about this issue of how to treat income, whether it's realized or unrealized?
So I think the best clue we have actually is what we talked about, which is, and it's kind of a version of legislative history in the sense of if Congress, or in this case, the drafters, were aware that there were different types of income and they were silent, then the best interpretation is they didn't want to include just realized income, for instance. And the other piece of interpretation that I think is important here is we're talking about decades of tax law that the Supreme Court has not questioned and that other people have not questioned. It's been since 1962 that we've had a similar type of tax where we can tax shareholders, owners of foreign corporations, on part of the increase in the money that corporation obtains, not on whether or not the shareholder gets a piece of the distribution of that increase in monetary value.
So then very briefly, why are we talking about this at all? In other words, if it's been pretty much standard practice, why is this before the court?
It's before the court because somebody challenged this 2017 law, and the lower courts were essentially united, and the Supreme Court decided to take the question, which I think indicates that at least some of them might be open to looking at this again. But if you listen to oral arguments this morning, I think they were very worried about what would happen if they ruled in favor of the challengers here.
Jessica Levinson breaking it down for us once again. Thanks so much.
Thank you.